Raskin.
Thank you, Mr. Chairman. After producing 9,000 pages of documents and saying he would comply with the committee's subpoena, after agreeing to come and testify, and after extensive cooperation with the committee, Mr. Meadows' book, The Chief's Chief, came out, and President Trump exploded and called it fake news. And Mr. Meadows amazingly echoed that and agreed that it was fake news, and then he said he would no longer participate. He would not come and testify, to the astonishment of everyone on the committee, after saying he would come forward. Then he goes to court as a delaying game, as you say, Mr. Chairman, to try to throw a monkey wrench into the process he'd been cooperating with up until Donald Trump blew his top. His central argument there is that we have no legitimate legislative purpose in conducting this investigation. Okay, so that's the heart of the matter. I want to read to you guys Article 1, Section 8, Clause 15 of the Constitution under the powers of Congress. Congress has the power to provide for calling forth the militia to execute the laws of the Union, to suppress insurrections, and to repel invasions. Mr. Chairman, what do you make of the claim that the Congress of the United States, the House of Representatives, does not have the power to investigate a violent mob attack on the Capitol of the United States? What happened, how it got started, who paid for it? What do you make of that claim?
Well, I think it's just patently wrong. Clearly, H.R. 503 gives us the authority as a committee to look at all the facts and circumstances surrounding January 6th. And that's what we're doing.
Oh, it's very clear that House Resolution 503 commands us to do precisely what the committee is doing. But he's suggesting that it's somehow unconstitutional, that the Congress doesn't have the authority to investigate an attack on the government of the United States, an attempt to overthrow the election. Madam Vice Chair, what do you think about that claim?
Well, I think it's wrong, and I think the federal courts have also made very clear, just in the last 2 weeks or 3 weeks, that in fact the committee has stated a completely appropriate legislative purpose. So it's not an issue anymore.
Judge Chutkin, in looking at former President Trump's argument, said presidents are not kings, and the plaintiff isn't president. Mr. Chairman, this really goes to the heart of our system, doesn't it? Do we have kings here? Do we have lords and nobles and friends of presidents who don't have to respond to congressional subpoenas or court subpoenas if they don't want to?
It is not up to individuals. We're a nation of laws. And clearly, because we're a nation of laws, people have to respect those laws and follow them.
Ms. Cheney, do we have to remind some of our friends what the American Revolution was about and what our Constitution says? Does our Constitution allow for kings, nobles, lords, people who are above the law?
Certainly it does not. No one's above the law. We're a nation of laws. And I'm just so struck, frankly, by something my colleague from Texas said a few moments ago in talking about the attack on January 6th, when he said, quote, "It's what we do here." No, it isn't what we do here. That's not what we do here. We can have debates and discussions about the law, about policy, about what is an appropriate role, but January 6th is not what we do here, and it can never be what we do here. And we have an obligation and we have a duty to ensure that the functioning of the government, the official proceedings of Congress, and it's difficult to imagine a more important official proceeding of Congress than counting electoral votes, that those who might attempt through either action or inaction to obstruct or delay those proceedings, that we get to the facts, that we understand what our legislative role is in protecting this nation, protecting the Constitution, protecting this Congress from making sure that ever happens again.
Well,
Mr. Chairman.
Mr. Raskin, I'm from a part of this country where Congress had to pass laws so that people of color could vote. Because in my area, Even Benny Thompson getting elected, it took a Voting Rights Act for that to occur. I'm a third-generation person in this same little community I represent, but there has to be a place for our federal government when all else fails. And what you saw on January 6th was an absolute failure on the part of a lot of systems. And those systems are under review right now. So bringing witnesses to our committee, seeking testimony from individuals who have information, we are absolutely open to that process. We are not trying to tailor it in a particular direction. We want to get to the facts and circumstances. There's no ifs, ands, and buts about it. But the buck stops with our committee to come with an objective report based on the facts. And
Hey, haven't you overseen something like 300 witnesses coming in either voluntarily or under subpoena, complying with the requests of the committee? The vast majority of the people have participated, right?
Only 3 people at this point of the over 300 has not.
Ms. Cheney, the claim that a former president is not subject to legal process is extremely far-fetched, given the Supreme Court has found that the sitting president is subject to legal process. Do you remember a 1997 decision in a case called Clinton versus Jones? You remember the Paula Jones case?
I do.
And you remember the Supreme Court saying that the president of the United States, who's in office right now, is subject to civil suit? Is there any reason to believe that a former president is not subject to legal process, or even worse, that he can wave a magic wand and keep other people from having to testify?
No, and I think that that last point is really critical. There are issues that we are litigating here. There's no question. But people need to remember that the current president, as to many of the matters we are discussing, has waived executive privilege. Mr. Meadows has, in fact, received indication that from the sitting president, from the White House, that he needs to appear, he needs to testify. And we are, as we have said repeatedly, focusing on matters over which he has no ability, no possible claim of privilege. If he would like to assert privilege, he needs to appear and do so. A blanket notion that somehow I've determined I'm not going to appear because of privilege is not proper. Not
It has no
appropriate.
basis in the law, right?
Right.
Now, as you say, the executive privilege belongs to the President of the United States. Has President Biden come in to invoke executive privilege to stop Mark Meadows from testifying about what took place on January 6th?
No.
He is not.
He is not, right? And has former President Trump, Mr. Chairman, although he has no say in the matter, but has he even tried to come into the committee to block the committee from taking Meadows' testimony? No. Well, does the Constitution, Ms. Cheney, have an office of former president?
No. Now, it is the case that there are some instances where a former president may assert privilege. But in those cases where the current president has made the determination that he will not be asserting privilege, and there is a process that the committee is undergoing, then the former president does not have the power to stop the Congress from investigating an attack on Congress and to prevent people from testifying who have information about that attack simply because, of some notion that he can.
What if it would be embarrassing to him?
Right. Those are not privileges that exist in the common law. There's no basis for that.
Well, you say that a former president can try to raise a claim of privilege, which is exactly what Donald Trump did in Trump versus Benny Thompson. And now we have definitive rulings by the Federal District Court and by the D.C. Circuit Court of Appeals panel headed by Judge Millett on precisely that point. And Madam Vice Chair, I'm afraid you stated a little bit too categorically. I don't want people to think that a former president can just assert executive privilege and it works. He can raise the executive privilege as he just did, and he got slapped down so far at every level in the federal courts. And what's the analysis the court goes through? Well, it starts with the presumption, as you do, that under the American rule of law, everybody owes his or her complete truthful testimony to the Congress of the United States if it comes calling with a subpoena, just like in a court. That's the presumption, and the people have the right to know because this is a democracy. Now, what could be countervailing to that is some compelling interest provided by a president sitting, or an extremely compelling interest provided by a former president. And the D.C. Circuit Court of Appeals, with Judge Millett deciding, unanimously said not only was there no compelling or extremely compelling reason to overthrow the presumption that Meadows had to testify, Donald Trump did not even offer one. He could not even offer an interest. Well, what about the interest in doing this again someday? Is that a compelling interest that a president could incite a violent insurrection against the Union? Do we want to shield any information about that in order to protect a president from doing that in the future, Mr. Thompson?
I would hope not.
Ms. Cheney, what do you think about that?
No, of course not. And I think that the point that you're making is very important for people to understand. We all talk about executive privilege broadly. It's a qualified privilege. And when there is an interest, as there is clearly here, that is a privilege that does not shield entirely from someone's duty to testify. I would also say that we're at the point now where there are many of these details of what happened that we have heard so many times that I think it's really important for people to pause for a moment and recognize what we're talking about. When we say we need to ask Mr. Meadows questions about the President of the United States' effort to make Jeffrey Clark Attorney General, Mr. Meadows' questions about his discussions with members of Congress about that, and about what was at the heart of that determination, the effort to overturn the election results in Georgia and in other states. I mean, those are the kinds of things, if you had said a year and a half ago, I think people would have been stunned. But we have to be very sure that we don't become so accustomed to hearing the really grave details of what this president was doing that we move on from the importance of understanding the specifics and the minute by minute of what happened.
Well, and let me close with a couple questions about that, Madam Vice Chair. Last night, the committee invoked a whole set of messages that were discovered in asking questions to Mr. Meadows, including Republican lawmakers and others sending frantic messages saying, we are under siege up here at the Capitol. They have breached the Capitol. Mark, protesters are literally storming the Capitol, breaking windows on our doors, rushing in. Is Trump going to say something? There's an armed standoff at the House chamber door. We are all helpless. Here's some more. This one came from Laura Ingraham. It was identified. Mark, the president needs to tell people in the Capitol to go home. This is hurting all of us. He is destroying his legacy. Brian Kilmeade, please get him on TV, destroying everything you have accomplished. Sean Hannity, can he make a statement, ask people to leave the Capitol? Donald Trump Jr., he's got to condemn this excrement ASAP. The Capitol Police tweet is not enough. Meadows responding, I'm pushing it hard, I agree. Donald Trump Jr., we need an Oval Office address. He has to lead now. It has gone too far and gotten out of hand. Now, Madam Vice Chair, why is it not sufficient just to say, well, he complied up until the point when Donald Trump essentially told him to stop complying? Why is his testimony further needed by our committee?
Because there are well, first of all, it's compelled by the subpoena. He's required by our subpoena to both produce documents and to answer questions, to appear to testify. And there are a multitude of questions that we need to ask him. We need to ask him, we need to understand what was going on, what were his discussions with the member of this body about making Jeffrey Clark Attorney General. Why did they want to make Jeffrey Clark Attorney General? What did he think about the letter that Jeffrey Clark was proposing to send to state legislators in Georgia to overturn the results of those elections? Why were Fox News hosts texting him, telling him that they needed to get the president out to stop this? Why did they think that the president was the one who could stop this? Because many of those same people now are in fact saying, gosh, this was just tourists. Or this was a false flag operation, another person on Fox News has claimed. So I think there are real questions about what those discussions were. I think there are questions we need to ask about what their plans were, what plans they were making on January 6th, what plans they were making with respect to the vice president, what plans they were making to have the vice president to get outside legal counsel to tell the vice president that he could in fact decide not to count certain electoral votes. The American people deserve to know all of the steps that Donald Trump, that those around him, that his campaign were taking in an effort to change the results, to overturn the election, to delay the electoral count. And again, the messages that Mr. Meadows has turned over are non-privileged, and he has a duty under
Everyone agrees
subpoena.
to that. No one
Right.
claims. So the executive privilege argument, as the chairman said, is pretty much a distraction at this point, because we're
It's a
talking about
pretext.
questioning him about things that he's already
And
produced.
he has a duty under the subpoena. He also has a duty as an American citizen, and he has a duty as somebody who served in a position of public trust, who swore an oath under God to our Constitution. He's got a duty to come forth and tell us what he knows.
Thank you.
Well, and the vice chair is absolutely correct. The other thing, Mr. Raskin, is this information was provided by Mr. Meadows to the committee. And what we gleaned from that information was enough that we needed to have him in person to come and explain the information that he had provided to the committee, of which he's denied to come.
Well, let me ask you about it, and then I'll close with this question, Mr. Chairman. You know, there's so much cynicism now in the public. Some people would invite us to believe that everything that happens in our politics is just lies, disinformation, fake news. What's the importance of the committee actually trying to establish the facts of what took place?
Well, I think absolutely. That's the core objective of the committee, is to get to the facts and circumstances that we can prove. Now, I think part of what you just read, why would all these people text the President of the United States and say, you have to stop these people? There's some connection between those individuals doing the text and who they're doing it to. And our committee needs to figure out in our investigation what those connections are. And the only way we can prove and get to those connections is have the people who are communicating with that to come before the committee.
You mean they weren't texting you to call it off?
No, sir.
Were they texting you, Ms. Cheney, to call it off?
They were not.
Seemed just to go to Mr. Meadows and the president. I yield back to you, Mr. Chairman.
Ms. Scanlon,